"She's mentally unstable," my mother-in-law Constance declared from the witness stand, her voice trembling with practiced emotion. "Erratic behavior, mood swings, neglecting the children while she obsesses over her work. She's completely unfit to raise my grandchildren." My father-in-law Harold provided corroborating witness statements from family friends, and my ex-husband Marcus smiled victoriously from the petitioner's table, already planning which bedroom each child would have in his parents' estate. But why did the court-appointed psychologist rise unexpectedly from her seat, and why did her next words transform the courtroom from my execution chamber into something else entirely? "Your Honor, before I present my evaluation, I need to make a disclosure." Judge Patterson looked up from her notes. "Proceed, Dr. Williams." I recognize the respondent. "She's Dr. Elena Petrova, the forensic psychologist who trained me during my residency at Johns Hopkins." Dr. Williams turned toward me with an expression of barely suppressed admiration. "She literally wrote the textbook we use for competency evaluations in family court proceedings. Her protocols are the standard for every custody assessment conducted in this state." The smug satisfaction drained from Marcus's face. "More importantly, Your Honor, I need to report what I discovered about the petitioners during my investigation. The evidence of parental unfitness exists, but it points in a direction this court hasn't anticipated." Constance gripped the witness stand railing. "What evidence?" "We're the ones filing the petition." "Yes, ma'am. And that's precisely what concerned me. I'd spent 20 years building expertise in forensic psychology. My specialty was custody evaluations, the delicate, crucial work of assessing which parent could best serve a child's needs after divorce. I'd trained hundreds of psychologists, testified in thousands of cases, and written the textbook that had become the standard for family court assessments nationwide. The irony of sitting on the respondent's side of a competency hearing was not lost on me. Marcus and I had divorced 2 years earlier, after I'd discovered his affair with his law firm's paralegal. The marriage had been struggling for years, his resentment of my career success, his family's constant interference, the gradual erosion of whatever partnership we'd once built. The children, Sophia, 12, and Michael, 8, had adjusted well to the divorce. They lived primarily with me, saw their father on alternating weekends, and seemed to be thriving despite the family upheaval. Then Marcus's parents had decided to intervene. The competency petition had arrived 3 months ago. Constance and Harold Morrison had filed for emergency custody of their grandchildren, claiming I was mentally unstable and creating an unsafe environment. Their evidence included witness statements from family friends, allegations of neglect, and a narrative about my obsessive work habits and emotional volatility. Every allegation was fabricated. But fabricated allegations, presented convincingly, could destroy lives in family court. I'd seen it happen countless times in my professional work. Vindictive family members weaponizing the court system, using children as pawns, exploiting custody proceedings to punish ex-partners. I'd testified in dozens of such cases. I'd never expected to be the target. Marcus's motivation was transparent: control. He'd lost the divorce, lost the house, lost the social standing that came with being married to a prominent professional. Taking the children would restore his family's narrative, the Morrisons as victims of a cold, career-obsessed woman who never deserved to be part of their legacy. His parents' motivation was even simpler: they'd always hated me. The Morrison family had opposed our marriage from the beginning. Constance had expected Marcus to marry someone from their social circle, a woman who would defer to Morrison family traditions, produce appropriate grandchildren, and know her place. Instead, he'd married an immigrant's daughter with an unpronounceable last name and an intimidating career. "She's very accomplished," Constance had said at our engagement party, making the words sound like a diagnosis. For 15 years, she'd undermined me at every opportunity. Criticized my parenting. Questioned my career choices. Suggested, repeatedly, that the children would be better off spending more time at the Morrison estate. When the marriage ended, she'd seen her opportunity. The custody petition was her weapon. The witness statements were from Morrison family friends, coached to provide testimony that fit the narrative. The allegations of instability were designed to destroy my professional reputation while taking my children. They'd expected me to collapse. To be overwhelmed by the accusations. To capitulate rather than fight. They'd badly underestimated who they were fighting. The court-appointed evaluation was supposed to seal my fate. In custody disputes, court-appointed psychologists conduct independent assessments, interviewing parents, observing family dynamics, reviewing evidence. Their reports often determine outcomes. The Morrisons had been confident. Their lawyer had presented their narrative effectively. The witness statements were consistent. The picture of an unstable mother seemed compelling. What they hadn't anticipated was that the evaluator would recognize me. Dr. Sarah Williams had been my student 15 years ago, one of the brightest residents I'd trained. She'd gone on to build an excellent practice in forensic psychology, eventually becoming one of the court's most respected evaluators. She hadn't recognized my married name on the case filing. She'd realized who I was only when we'd met for the initial assessment. Dr. Petrova? She'd stared at me in the evaluation office. You're the respondent? Apparently even textbook authors can become targets. I need to disclose our relationship to the court. I can't evaluate you fairly, actually, you can. Better than almost anyone. You know the difference between genuine instability and fabricated allegations. You know the methodology better than anyone because I taught it to you. She'd hesitated. What if my evaluation favors you? It'll look like bias. Then make sure your investigation is thorough enough that the evidence speaks for itself. I'm not asking for favorable treatment. I'm asking for accuracy. Dr. Williams's investigation had taken 6 weeks. She'd interviewed me, Marcus, both children, both grandparents, teachers, neighbors, and everyone who'd provided witness statements for the petition. She'd reviewed documentation, observed family interactions, and applied the exact methodology I'd developed for competency assessments. What she'd found had transformed the case. Your Honor, she continued in the courtroom, the petition alleges that Dr. Petrova is mentally unstable and unfit for custody. My evaluation found no evidence supporting these claims. Her psychological profile is consistent with a high-functioning professional managing the normal stresses of single parenthood. She's covering for her mentor, Marcus's lawyer interjected. There's obvious bias. Counselor, I disclosed my relationship with Dr. Petrova to the court precisely because I anticipated this accusation. My findings are documented with the same rigor I apply to every evaluation. Dr. Williams opened her report. What I did find, however, was deeply concerning. The courtroom went quiet. The witness statements provided by the petitioners contained significant inconsistencies. Several witnesses, when interviewed individually, contradicted their written statements. 2 admitted they'd been coached by Mrs. Morrison on what to say. Constance's face went pale. More concerning, I discovered evidence of what's known as parental alienation being conducted by the grandparents, systematic attempts to damage the children's relationship with their mother through manipulation and false narratives. The evidence Dr. Williams presented was devastating. During her interviews with Sophia and Michael, both children had revealed disturbing patterns. During visits to the Morrison estate, their grandparents had told them their mother was sick, that she didn't really love them, that she cared more about her career than about them. Grandma says Mom is going to go crazy and hurt us, Sophia had reported. She says we should come live with them so we'll be safe. Grandpa told me Mom might have to go to a hospital for crazy people, Michael had added. He said that's why they're trying to help us. The children had been confused, frightened, and manipulated, not by me, but by the grandparents claiming to protect them. These statements constitute documented evidence of deliberate psychological manipulation of minor children, Dr. Williams stated. The petitioners have been actively working to damage the children's relationship with their mother while simultaneously claiming she poses a danger to them. That's not true. Constance shouted. We were trying to prepare them for the reality. Mrs. Morrison, you told an 8-year-old that his mother might be institutionalized. There was no basis for that statement. It was calculated to create fear and dependency. Dr. Williams turned back to the judge. Your Honor, I recommend not only that this petition be dismissed, but that the court consider whether the grandparents' visitation should be restricted pending family counseling. Marcus tried to salvage the situation. Your Honor, my parents were genuinely concerned. Their methods may have been misguided, but their intentions were to take custody of children by any means necessary, Dr. Williams interrupted. Including fabricating evidence, coaching witnesses, and psychologically manipulating their own grandchildren. You don't know what you're talking about. Mr. Morrison, I've evaluated hundreds of custody cases. I know exactly what manufactured allegations look like. I know the patterns of grandparent overreach. I know the damage that parental alienation causes to children. She paused. I know these things because Dr. Petrova taught them to me. Because she literally wrote the book on identifying exactly what your family has done. The irony landed with visible impact. They'd filed a competency petition against the person who'd written the competency evaluation standards. They'd tried to use the family court system against the expert who'd helped design that system. They'd manufactured evidence against someone who'd spent her career identifying manufactured evidence. Judge Patterson removed her glasses. This is the most extraordinary case of petitioner misconduct I've encountered in 20 years on the bench. The ruling was comprehensive. The custody petition was not just dismissed, it was sanctioned. The judge found that the Morrison family had filed in bad faith, using fabricated evidence to pursue custody they had no legitimate claim to. Marcus lost his alternating weekend visitation. The psychological damage his parents had inflicted on the children during those visits warranted supervised contact only, pending family therapy to repair the relationships they'd corrupted. Constance and Harold were barred from unsupervised contact with Sophia and Michael. Their deliberate psychological manipulation was documented in court records that would follow them if they ever attempted another custody action. Dr. Petrova, Judge Patterson addressed me directly. I apologize that you were subjected to this process. The court system you've dedicated your career to serving failed to protect you from weaponized litigation. The system worked, Your Honor. The truth emerged. The truth emerged because the evaluator happened to recognize you and conducted an unusually thorough investigation. Not every parent facing fabricated allegations is so fortunate. No, they're not. Perhaps that's something the system should address. The aftermath was complicated. Marcus attempted reconciliation, not romantic, but familial. He claimed he hadn't known the extent of his parents' manipulation, that he'd believed their concerns were genuine. You attended every hearing, I reminded him. You smiled when your mother called me unstable. You sat there while your father presented coached witness statements. I thought they were right. I thought you'd changed, that the work had consumed you. You thought what was convenient to think. What justified your family's actions? What let you believe you were a victim rather than a collaborator? Elena, the children will heal. Because I'm going to get them proper therapy, address the damage your parents caused, and rebuild what your family tried to destroy. I stood to leave. You could have stopped this at any point. You could have questioned the evidence, challenged your parents' methods, protected your own children from psychological manipulation. You chose not to. I didn't know. You didn't want to know. There's a difference. The children's recovery took time. Sophia, being older, understood more of what had happened. She'd been suspicious of her grandparents' statements about me but hadn't known what to do with her doubts. They said you were going to hurt us, she told me during one of our therapy sessions. I didn't believe it, but they kept saying it over and over. I started wondering if maybe they knew something I didn't. That's how manipulation works, sweetheart. Repetition creates doubt, even when you know the truth. Why would they do that? I thought they loved us. They love you in their own way. But they love control more. They wanted you living with them, following their rules, becoming the kind of grandchildren they'd imagined. When I stood in the way of that, they decided I needed to be removed. That's messed up. It is. And recognizing that it's messed up is the first step toward healing from it. Michael's confusion was simpler but no less painful. He'd been genuinely frightened that his mother was going to be taken away. Grandpa said you might go to a hospital and never come back, he'd whispered during one tearful evening. Like great-grandma did. Harold had used his own mother's institutionalization, decades ago, for conditions that were now treatable, to terrify an 8-year-old. The cruelty was breathtaking. I'm not going anywhere, baby. I'm healthy, I'm here, and I'm not leaving you. Grandpa was wrong to say those things. Why did he lie? Because he wanted something that wasn't his to take. And sometimes people lie to get what they want, even when those lies hurt people they're supposed to love. The professional implications were significant. The case became a teaching example in forensic psychology circles, the expert targeted by the very tactics she spent her career identifying. I was invited to speak at conferences about recognizing manufactured evidence and protecting legitimate parents from weaponized custody litigation. The system assumes petitioners act in good faith, I told one conference audience. But bad actors exploit that assumption. They know the language of concern, the structure of legitimate complaints. They weaponize our protective instincts against the parents we're trying to protect. What's the solution? Better training for evaluators. Mandatory investigation of witness statements. Penalties for documented bad faith filings that actually deter future misconduct. I paused. And perhaps requiring that petitioners undergo the same scrutiny as respondents. If you're going to accuse someone of parental unfitness, you should be prepared to demonstrate your own fitness as well. The Morrison case was cited in subsequent legal proceedings as an example of grandparent overreach and custody petition abuse. Some small good came from the damage they'd attempted. Constance and Harold never accepted responsibility. They maintained they'd been acting out of genuine concern, that their methods had been misunderstood, that the court had been biased against them. They hired lawyers to attempt appeals, all of which failed. They gave interviews to sympathetic media outlets, positioning themselves as grandparents denied access to beloved grandchildren. The documentation told a different story. The coached witnesses. The deliberate psychological manipulation. The fabricated evidence designed to destroy a mother's reputation and steal her children. Marcus eventually acknowledged what his parents had done, not to me, but to a therapist, during the family counseling sessions the court had mandated. I knew something was wrong with their approach, he reportedly admitted. But they were so certain, so convinced they were right. I wanted to believe them because it was easier than challenging them. And now? Now I've lost my visitation. My children are afraid of my parents. My relationship with them is supervised by court officers. He'd paused. I should have spoken up. Yes. He should have. The children are thriving now. 3 years after the custody battle, Sophia is 15 and Michael is 11. They see their father monthly, in supervised settings that gradually became less formal as he demonstrated genuine change. They no longer see their grandparents at all, their choice, supported by their therapists. I don't trust them, Sophia explained when asked about resuming contact. They lied to me, tried to make me afraid of my own mother. How can I trust anything they say now? People can change, I offered. Maybe. But they haven't apologized. They still think they were right. She shook her head. I'll consider contact when they admit what they did. Not before. Wise beyond her years. The damage had created unexpected growth. I returned to my professional work with renewed purpose. The case had shown me vulnerabilities in the system I'd helped build, ways that bad actors could exploit custody proceedings to harm children while claiming to protect them. I revised my textbook, adding chapters on manufactured evidence and grandparent alienation tactics. You're using your own case as a teaching example, a colleague asked. Why not? It illustrates everything I've spent my career warning about. The weaponization of protective systems. The manipulation of children as pawns. The assumption that people filing custody petitions must have legitimate concerns. Doesn't it bother you? Having your personal trauma become professional material? It bothers me more that other parents face the same tactics without the professional background to recognize what's happening. If my experience helps protect future families, then some good comes from what the Morrisons tried to do. The irony was complete. They'd tried to destroy my professional credibility by claiming I was mentally unstable. Instead, they'd become case study examples of exactly the behavior my professional work was designed to identify. The textbook author became the case study. And the case study proved that the textbook was right all along. They demanded a competency hearing expecting to take my children. They filed fabricated evidence, coached witnesses, and manipulated their own grandchildren. They thought they were dealing with an ordinary mother, overwhelmed and defenseless. Instead, they were dealing with the forensic psychologist who had written the evaluation standards. The court-appointed psychologist wasn't just fair, she was my former student, trained in the exact methodology her mentors had designed to identify manufactured allegations. They thought they'd found a weapon. Instead, they found a mirror. Every tactic they used was documented in textbooks I'd written. Every manipulation was cataloged in protocols I'd developed. They tried to destroy me using a system I'd helped build. The system worked exactly as I designed it, protecting children from adults who would use them as weapons, and exposing the petitioners who claimed to be protectors but were actually predators. They wanted my children. Instead, they got sanctioned, restricted, and documented for exactly what they were.